we explore the evolving landscape of European patent litigation. Today's episode is a continuation of our deep dive into one of the most pressing questions for European patent professionals. How closely aligned is the UPC's case law with that of the EPO? In part one, we looked at the early trends in inventive step, novelty, and added matter. This time, we turn to claim interpretation, the impact of the G124, and procedural nuances like burden of proof and substantiation. I'm joined once again by Mr. Tilman Pfrang, the UPC representative, European patent attorney, and our all-around go-to guy at the interface between EPO and UPC practice. Tilman, welcome back.
Hi, George. Good to be back.
So we've got a pretty interesting show as always. And this time I want to start off as we parallel from our last session to the G124 and the end of the only if unclear rule. So Tilman, let's talk about claim interpretation. The EPO's enlarged board recently issued a decision for the G124, clearly moving away from the only if unclear rule. How has this affected the proceedings before the UPC, and are we seeing similar interpretive freedom in the UPC case law?
Yeah, George, G1 out of 24 is actually a very good example how the two authorities are moving towards each other, how they are converging. To discuss G1 out of 24, one must understand that there were two traditions in the history of Court of Appeal practice. The one line of case law established the so-called only if unclear rule, meaning they said, well, as long as the claim as such is clear, we do not even have to look into the description, or we should not look into the description. Then we keep the claim as it is in a certain sense. Another line of case law was opposing this and said, well, we have always look into the description and figures, by the way, too. They referred partly to Article 69 EPC, which is dealing more with patent infringement, one might argue. Some also referred to Article 84 EPC, which is dealing more with clarity. Some said, well, this is just a general principle. In any event, there was this divergence within the EPO. And now 2 years ago, the UPC came into play, and the UPC took very early a very clear stance on this. They said, even in one of the first Court of Appeal orders, they said that we always have to look into the description and the figures. And this is not only relevant for patent infringement, but also for patent validity. So meaning in counterclaim, revocation counterclaim proceedings or isolated revocation proceedings, we also have to look always into the description. And now it was very nice to see for us practitioners that the enlarged Board of Appeal actually confirmed this. So they did not say, well, we have our own approach, or maybe we even endorse the only if unclear rule. No, we go with the UPC and the Court of Appeal of the UPC. And in our opinion, you always have to look into the description, the figures when interpreting the claim. And they brought up, from my perspective, a very nice logical argument. They said, I mean, in the end, in order to come to the conclusion that the claim is clear, this is already an interpretative act. So in this situation, you have interpreted the claim, and you can only interpret the claim under consideration of the description. So they said, and I agree with that, it's kind of unlogical if you say, well, I act as if I would not know the context of the claim, as if I would not know the description and the figures, which I do know, of course.
So before you go on, are you saying that is an interpretation so clear and unclear? Is this that would somebody use the tactic, it's unclear, so I need to try this, even if it's very clear? It's a crazy question, but if it's clear, the judge says it's clear, and the ruling is it's clear, but somebody says, but it's unclear to me.
I don't think that the question is so crazy, and I think this actually brings us to the gist of all of this question, because my argument was always there is not such a thing as a clear claim, meaning clear in itself. And we could play a game. We don't have the time for that, but we could maybe next episode we could play a game. You present me something where you a claim where you say, well, this is clear in itself. And then I'm 100% sure I could give you examples where you would no longer say it's totally clear whether we are working within the claim or outside of it.
So you're
It's
saying you could poke
always
holes into it. Yeah.
always. There's always a certain ambiguity. Maybe you do not see it at the beginning, but at the moment where you bring examples, and the high number of infringement proceedings, by the way,
Yeah.
show that too, that there's always a gray area. Every claim has a gray area. So even and this is my answer to your question.
Yeah.
My answer is there are no clear claims anyway.
Excellent rhetorical. So the procedural influence, do UPC judges think in UPO structures? I mean, in your experience, Tilman, do you see judges at the UPC, many of whom have national court or EPO backgrounds, adopting EPO style procedural reasoning in how they frame their decisions? Is there a visible impact from the problem solution mindset?
Well, do UPC judges think in EPO in an EPO way? I don't think so much. For the moment, I have the feeling, at least at the beginning, they were thinking a lot in their national
Interest
ways.
okay.
One reason is there are UPC judges with relation to the EPO, former Board of Appeal members as technical judges, as far as I know. But I don't see a dominant role of them. I see a very dominant role of the national judges be it in Munich or The Hague or whatsoever.
Mm-hmm.
And the reason for that is that at the local divisions, normally 2 of the 3 legal members are from that country. And also all countries, specifically Germany, have sent their most experienced judges to the UPC. And I see a lot of thinking which is very similar to national court practices we know from the district court in Munich or the district court in Düsseldorf, and we find again at the UPC at the corresponding local division in Munich or local division in Düsseldorf or local division in Mannheim. Similarly, a good example for that is also how the Hague division dealt with equivalent patent infringement.
Okay.
A lot in the very first decision on the topic was based on traditional national Dutch law.
Mm-hmm.
However, also with substantial, let's say, adoption of German practice. So actually, at least in one point, they explicitly, or not explicitly, but implicitly, they deviated from the Dutch practice and adopted a German practice. So they also mixed things a bit. Yeah.
Are you saying, is there an advantage or disadvantage when you think about if they stay with their national identity in the EPO courts?
I think it's unavoidable, at least in the beginning. You must know that, I mean, these experienced judges, they decided for many decades, some of them 20 years or so, they handled patent infringement cases. And the law remained the same, the substantive law remained the same. So questions such as how to interpret the claim, it's the same as before. Article 69 EPC. And also the claims you can raise are mostly identical or highly similar. So the injunction relief or damage compensation. So
right.
So it is unavoidable. I think that at the beginning they stick very much to their national traditions, because otherwise they needed to say, well, we were wrong for 20 years, and now only because we are sitting in another chair.
I got you.
It's different. So, well, yeah.
A good question, good answer there. Which court is stricter? That's the next question. So let's turn the question around. Are there any areas where the UPC is more demanding than the EPO, for example, in assessing added matter or sufficiency? I mean, could patentees be caught off guard by procedural or substantial strictness at the UPC?
From a substantive perspective, I don't see more strictness. We have discussed this in our first episode on that topic, that there are still differences in assessing in massive step, at least if you compare some of the local divisions of the UPC with EPO practice. But I would not say that the one or the other is more strict. From a procedural perspective, yes.
Okay.
There, one must add that in particular the boards of appeal of the EPO have become extremely strict in the last 10 years or so. When I started almost 20 years ago, it was, for example, still possible, or you had at least a chance presenting a new auxiliary request in oral proceedings in the second instance with a feature from the description. This is no question now. This you should not even try. No chance at all. And this has become stricter and stricter over the years. The Board of Appeal has become extremely strict. What I see also that the first instance more and more adopts the strictness of the Board of Appeal. However, if we compare the first instance of the EPO with the first instance of the UPC, I would say that the first instance of the UPC, so the local divisions and sometimes the central division, are much more strict than the opposition divisions, for example.
Well, you bring up a great point where you say that they're very strict and there's no chance, but you're a pretty good practitioner and you can poke holes in mostly everything, but you still say there's no chance.
Thank you for the compliment, George. I mean, what I can only recommend: never give up. I mean, if this is your last chance, maybe you find a good argument. Maybe the members of the Board of Appeal have a very, very good day, and for some very exceptional reason, they accept your auxiliary request. I mean, you cannot lose anything by presenting a further auxiliary request if anything else is lost. But I cannot remember, at least for 5 years or so, that something like that was successful. So.
Right.
I mean, you should never give up, but you should also know the probabilities of your
being reasonable about your chances. So the procedural fairness, the burden of proof and substantiation requirements. We're also seeing growing attention to procedural rules and who has to prove what and how. Would you say that the UPC's burden of proof requirements reflect EPO case law, or are they evolving differently?
I think there are parallels and maybe also differences. Parallel is, and this is not only a parallel between UPC and EPO case law, also I would say to German national case law and probably many other jurisdictions, that normally the party who presents a fact which is supposed to speak for their case is prove that fact if disputed. And there is maybe already some subtle difference as to disputation of facts. What we have learned, at least from the Düsseldorf local division, is you cannot simply say, I dispute the fact by pleading ignorance, meaning that I simply say, I just don't know, and with that I dispute. You must always substantiate. This is different to German practice, for example, where you can dispute facts by pleading such ignorance. And
such ignorance. So as ignorance meaning as you weren't aware of something or whatever.
Non-knowledge.
Okay, got you. Okay, got you.
Non-knowledge. This is actually the literal translation in German practice. We call it Nichtwissen. Bestreiten mit Nichtwissen. So pleading non-knowledge. And here at the UPC, however, a fact is considered true, so this is a procedural truth in the end, if not disputed. The court will not investigate whether or not it is factually and actually true. At the EPO, this is similar in practice very often. If it's not disputed, they tend to say, well, then just believe it. Why shouldn't we? But on the other hand, they are obliged to investigate the case. The UPC is not obliged to investigate the case.
Oh, really? Okay.
So they could well say, okay, it's not disputed, but still we don't think this fact is true. This is actually at least difficult for the local divisions of the UPC. So as to burden of proof and substantiation of facts, I would say that the UPC proceedings is more dominated by procedural constraints, and the EPO is more free, in particular in first instance, to investigate on their own.
Okay, so would it come to the phrase same but different?
Yes.
Great. So moving on, the fragmentation risk. Will divergence grow or shrink? That's a good question. And looking forward, do you expect EPO and the UPC case law to grow more aligned over time, or will procedural and institutional differences inevitably lead to divergence?
Yeah, as far as I know, the best weather forecast is always to say it will be same as today, right? So
It's the
it,
safest, yeah.
it's the safest, and actually, I think, or at least some years ago, it was still the most accurate. Here, I think can assume something similar. What we see in particular in the most recent 6 months or so, I see actually an accelerated convergence even.
Okay.
So if just one example, we have discussed G1 out of 24, where the large court of appeal even said, well, it would be a mess in the end if we disagree with the UPC in relation to claim interpretation. Or you can also refer to the Munich local division, which explicitly said, well, the problem solution approach is okay or a good thing on its own, but our main motivation to use it is because we would like to harmonize patent law and together with the EPO. So in brackets, they didn't say together with the EPO, but for the reader, it's clear this is an EPO idea, an EPO construct the problem solution approach. And if they adopt it to harmonize, they say, well, we would like to approach the EPO. And at the beginning, I wasn't so sure. I've even seen tendencies that some local divisions wanted to make a point in contrast to EPO practice, and maybe even the other way around, but I cannot give you examples for that. However, in the meantime, I see a clear willingness of convergence. And again, my weather forecast example, if this continues, then it must get closer and closer so that the differences would be nullified in the end.
So you're saying that the EPO and UPC might purposely try to be different on in the way they adjudicate things, even though they have some of the same borderline things.
Meanwhile, I would not say this anymore. Some early decisions of the UPC made sometimes the impression. Now I don't have this impression anymore. I think the opposite. They try to come together.
Interesting. So then the strategic takeaway for practitioners, this will be good. What are your key takeaways for the European patent practitioners who litigate before both the EPO and the UPC? How should they handle cases differently or not, and based on the evolving jurisprudence?
Yeah, I mean, this is a rather difficult question, actually. Practitioners who litigate before both the EPO and the UPC, it depends a bit. Is it the same case or is it different cases?
Mm-hmm.
If it's different cases, I mean, the answer is not so difficult because both systems are very heavy front-loaded. Mm-hmm. So a general advice would always be present everything you have as early as possible and be prepared as good as you can be from the very first second when filing the opposition brief or when filing the statement of claim at the UPC. When you're in the unlucky position, in particular on the patentee side, to litigate both at the EPO and the UPC at the same time, then it can get very messy because usually you have an incentive to present auxiliary requests, let's put it that way.
Right.
And then it may well be that the UPC decides before the EPO or the other way around, and you do not know this before. And what you must expect that both proceedings at the EPO and the UPC run in parallel with maybe a potentially different outcome. So you must be very well aware of this problem and, for example, adapt your strategy within the EPO proceedings and the opposition proceedings to what's going on at the UPC at the same time. I would highly recommend, for example, that you present the same claim sets, because if you don't, it may become even more difficult. Then in the end, the likelihood is increased that the EPO upholds a different version of the patent compared with the version the UPC upheld, and then you face severe difficulties.
Mm-hmm.
What's a shame a bit is that you cannot. I don't see a procedural solution for that, maybe by analogous application of other rules, but you cannot present different claims for the UPC territory within the EPO opposition proceedings compared to the rest of the EPC member states. So you
Okay.
cannot say, for example, for the UPC territory, I restrict my claim with feature X, and for the rest, I restrict with feature Y. This is not foreseen in the EPO, and I think this
Okay.
should be added either that you say, well, analogously. Why do I say analogously? Because there is one option to present different claim sets, and the one option is if there is a national post-published prior art.
Mm-hmm.
I do not want to go too much into detail, but you can say, well, therefore I present for Germany another claim set than for the rest of the EPC countries. And I think this should be also possible for the UPC territory, for example, in total, and for the rest of the EPC member states.
Would that be more of a strategy, like a limited approach? Although you want to do front loading at all costs, but then you're saying that we'll do a limited rollout for this and a front loading for that. Does that make sense, or is that I'm a little bit confused on that?
That's a good point again. I mean, the problem you face is that the speed of both proceedings will not be the same, and I cannot even say it depends on the case. That
Right.
The EPO will be quicker or the UPC, and yeah, actually, when preparing your UPC case, you should also, from the very first second, do everything so that it does not conflict with the EPO proceedings you're facing.
Right.
So that's a good point, actually. Front loading, also including such strategic thoughts, so more front loading in overall for the entire circumstances of the case, and not only for the specific UPC proceedings.
Good. So that's going to wrap up part 2 of our discussion on the convergence and the divergence between UPC and EPO case law. Many thanks to Mr. Tilman Pfrang, our good friend from the show, for guiding us through these subtleties of the claim interpretation, procedural reasoning, and strategic takeaways for practitioners. Very good points, excellent points made, Tilman. And if you found today's episode helpful, please subscribe, share, and leave us a rating. And don't forget to check out our earlier episodes on inventive step and preliminary injunctions under the UPC. Until next time, I'm George Walden and Tilman Pfrang here. Thank you for showing up and coming with us and giving us some really great insights. And this was the UPC Insights show. Take care. Until next time, see you soon.
See you soon, George. Thank you.
Bye-bye.